government-backed plans to criminalise upskirting were derailed yesterday after they were opposed by a veteran Conservative MP. The upskirting practice is basically involves taking a picture of a person's underwear without them knowing, and there were plans to make it a specific criminal offence, carrying up to 2 years in jail under the voyeurism bill. There were cries of shame yesterday on the Commons benches after Sir Christopher Chope formally objected to the legislation. This despite the government endorsing the new laws, getting cross-party support. It took one cry of object from Sir Christopher for the whole thing to go to the back of the queue. Just as quickly as it was ended, did Tory MPs run away from their colleague. Connor Burns, the Conservative MP for Bournemouth West, wrote on Twitter yesterday, embarrassing behaviour by Chris Chope this afternoon. Not for the first time. I share a constituency boundary with him, but clearly not a century. We're going to hear from a victim of upskirting and also from a journalist who has written in defence of Sir Christopher Chope in a few moments' time. Let's first look at the background to what this bill was proposing. Joseph Kotrie-Monson is the director of Mary Monson Solicitors, who are specialists in sexual offences and serious crimes. Morning to you, Joseph.
Good morning, Tom.
I suppose there are people suggesting that Christopher Chope's objection to this was because it was an unnecessary bill. It didn't need to be a specific offence. What's your view?
Well, I think that's absolutely wrong, and I think also his objection is more ideological, Tom, but more on that in a moment. Upskirting is a practice which can't be regarded as outraging public decency, very old offence, which is an offence involving something more overtly sexual, and upskirting can't be regarded as voyeurism, which it's probably closest to because it's not a private act. It's basically photographing somebody's knickers. If that floats your boat, you're probably a complete idiot and a bit of a psycho. But upskirting is an activity that ranges between, in the real world, what might be called, and Tom, I don't like this word, and if you've got a better one, please tell me, laddish and obnoxious behaviour, to, on the, at the other end of the spectrum, a disturbing offence for sexual gratification. So it's an activity a behaviour that we find abhorrent, and some of the stories that you and I have both heard and listeners have heard in recent months have ranged between people feeling very targeted and humiliated to actually being, seriously facing serious psychological damage as a result of the ordeal of the humiliation.
And is it the case, Joseph, that were this bill to have gone through, that it would be, if you were caught upskirting, you would go immediately to face 2 years in prison?
No, certainly not. And it's the case. And if anyone's saying, well, maybe this was a bill that just went too far, that's absolutely not the case. I'm a defence lawyer, so usually I'm fighting against prosecutions, but I'm very sympathetic to what's being trying to achieve here. And the range is up to 2 years. And if you look at voyeurism, for example, a single instance of voyeurism, taking photographs of somebody on the beach or something like that, as odious as that is, probably for a first offence, isn't going to result in a prison sentence. It's up to 2 years. That means a maximum after trial. 2 years. At the other end, of course, you have voyeurism and upskirting. You can think of parallels here too very easily. If somebody is taking multiple photographs of different victims, for example, with a hidden camera in a shower, well, I think we'd probably expect that person to go to prison for a longer period of time or for a substantial amount of time. And upskirting is the same, because there are upskirters who take sexual gratification. Tom, what we have here is a clear gap in the law, because this is a new type of behaviour because of the prevalence and availability of cameras and videos on phones. That gap in the law needs to be filled by government. It hasn't. Instead, we've got a private member's bill. I don't know why, but the government isn't taking responsibility for it. And it has been frustrated by one of this hardcore group of backbench MPs, Tom, who always object to private members' bill.
And what the difficulty with this, Joseph, and I'm grateful for your time and your background on this, Joseph Kotrie-Monson, director of Mary Monson Solicitors. Part of the problem with this is that we haven't heard from Sir Christopher Chope as to the reason why he objected to this bill going through. We'll hear from a journalist in a moment who believes they know why he did, and it was on perfectly legitimate grounds. We'll speak to Melanie McDonagh in a few moments. 8:09 is the time. Let's speak to Rebecca Reid, though, writer for the Telegraph and the Metro, and a victim of upskirting. Rebecca, thank you for your time this morning. Just briefly, if you would, describe what happened to you.
So I was upskirted when I was 15. I was in a park with some friends. A guy I was sitting on a slight incline with my knees sort of up to my chest, and he sort of put his phone under my skirt, took a picture, and then showed all my friends. Tried to get everybody to guess whose crotch it was. Refused to delete it.
Did you know who this person was?
Yeah. He was a friend. Well, friend is a loose term. But the issue was, because this was not illegal, and I'd never even heard of this being a thing, I didn't think I had a leg to stand on. So when I got in touch with him subsequently to say, please will you delete it, and he said no, I didn't know what to do. I didn't feel like I could insist. So I think the really important thing about this is that when it is illegal, and when it is made formally illegal, which I truly believe it has to be, girls will finally understand that if this happens, not only is it unacceptable, you have recourse for it.
Is 2 years, though, too much for this type of offence?
The likelihood of you getting 2 years for this is infinitesimal, and then we have to remember that if you're sentenced to 2 years, you never serve 2 years. You serve usually half your sentence, and the maximum sentence that something carries is very rarely what people are given. So the likelihood is, if you were actually sentenced to 2 years, it would be because you had been doing this over and over and over again, and you were a repeat offender. The likelihood of a teenage boy being sent to prison for a year is tiny. What it means is that there is an awareness that you could get in trouble for doing it, which is worth having, because in what world do we need to protect the right of somebody to photograph somebody else's underwear without their consent?
The Prime Minister has waded in on this. Speaking last night, she tweeted, "I'm disappointed the bill didn't make progress in the Commons today. I want to see these measures put into Parliament as soon as possible." Rebecca, hang on the line there, because I want to bring Melanie into the conversation. Melanie McDonagh is a journalist who has written in defence of Christopher Chope's upskirting objection. It's an article in the Spectator. Melanie, thank you for your time this morning. Give us the reasons why you think he objected and why he was right to.
Well, I think that if you're going to introduce a criminal offence, it can't just be put through on the nod. But as you discussed earlier, the proposed punishment for the offence could be as much as 2 years, or being put on the sex offenders register, which actually could compromise your career for the rest of your life. So this is too significant to move simply to be put through without debate. It deserves at least debate. And what my thinking would be is that already the most likely way it could be prosecuted would be as a way of outraging public decency, and that hasn't happened in the case of Gina Martin, who introduced the online petition because she was wearing underwear. At least that was what she said the police said, which is extraordinary to me. And so amending the offence against public decency, which is technically called outraging public decency, could be amended for this purpose.
Can I just jump in here and say that in Scotland, it has been this legislation has been formalised since 2010. So we're not talking about people got together and wrote down on the back of a fag packet, "Let's send boys to prison if they make a mistake." This is legislation that's already in place in a part of the UK.
Yeah, it's not to say that they were right to do that. I think that you're introducing a prohibitive sentence for something which is completely unacceptable behaviour and despicable behaviour, but not in itself a criminal offence warranting such a serious level of punishment.
Melanie, let me jump in for a sec. How do you know that this is what Sir Christopher is objecting to?
Well, I can't read Sir Christopher's mind.
Because a lot of people are saying that the reason why he's... Hang on a sec. The reason people say that he is objecting to this is because he's unhappy at the process by which this has been brought in rather than the specifics of it. He doesn't like backbench MPs getting to make the law, basically.
Well, my understanding was that he didn't like the procedure being nodded through because, as matters stood, the bill could have been passed into law on the basis of no debate whatever, unless he'd actually articulated the word object. Now, because he's done that, it will be necessary to reintroduce it with a level of debate, and I would have thought that was the minimum precondition necessary before you bring in an offence which has such serious consequences for the potential offender.
Rebecca, your thoughts?
Again, I just think it's really important that we remember that this is legislation that is already in place in Scotland, and that since 2010 there has not been a single case of somebody making a mistake and being sent to prison for 2 years. Very often the ability to sentence somebody is given in a much longer sentence than you would actually give, so that people have the option, so that when a judge and a jury have the option to sentence somebody, they can do it. And I really struggle. I feel like this is such an obvious conversation, and I do not understand why there always has to be someone who wants to play devil's advocate. We know that taking pictures of women's underwear without their consent is not okay. Why do we have to have this silly point-scoring conversation? Why can't we just protect women?
Rebecca, we'll leave it there. I'm grateful for your time this morning. Rebecca Reid, writer for the Telegraph and the Metro, victim, as you heard, of upskirting, and Melanie McDonagh, a journalist who has written in defence of Christopher Chope's upskirting objection. It's a piece in the Spectator.